Hi guys, welcome to my YouTube channel Apex Shorthand Dictation. Please subscribe my channel and press the bell icon. Get ready, start. We follow and apply this well-settled principle of law for rejecting the submissions of learned counsel for the appellant's stop. In the light of aforementioned 12 reasons, we are of the view that Goody within bracket PW9 was rightly held to be an eyewitness and two courts rightly relied upon her sworn testimony for sustaining the appellant's conviction. Stop. This takes us to the next argument of learned counsel for the appellant's stop. It was urged that the alleged recovery of articles on the strength of disclosure statement of the accused and in particular the double inverted comma asses and the bones from the canal is not possible. Stop. We do not agree. Stop. Para. In our view, there is no evidence to prove the fact as to whether the canal from where the recovery of ashes and bones was made had any water therein or not at the relevant time. Stop. We do not find that any question was put to any witness on this issue, and secondly, no independent evidence was brought on record to prove as to whether the canal was full of water or had no water therein. Stop. In any event, one could not dispute that bones were recovered from the canal. Stop. In the absence of any evidence, which could otherwise be laid in any form, this submission at this stage is, therefore, not acceptable. Stop. Para. This takes us to the next argument of learned counsel for the appellant's stop. Learned counsel urged that why the prosecution did not examine any independent witness from the village other than Goody PW9. Stop. We find no merit in this submission for more than one reason. Stop. First, no such argument was advanced before the two courts below. Stop. Second, the incident had taken place during midnight when all the villagers were fast asleep. Stop. Third, no evidence was adduced to prove that near the place of incident, there were many houses, and lastly, had the injury been caused by gunshot, it would have created some noise in the nearby locality and attract the attention of the villagers. Stop. Such was, however, not the case because the weapon used in commission of the offense was gandasa. Stop. In our considered opinion, the disclosure statements made by the accused during their interrogation on the basis of which the recoveries of articles were made such as gandasa, bones, ashes, blood stained bricks and earth, tractor with cart, two plastic cans smelling diesel oil, which were duly proved by the investigating officer, are sufficient to sustain the conviction when it is examined in the context of oral evidence. Stop. Merely because no expert opinion was obtained to prove as to whether bones recovered were human or animal bones, in our view, would not weaken the case of prosecution in the light of overwhelming evidence available on record to prove the complicity of the appellants. Stop. Para. In view of foregoing discussion, the appeals are found to be devoid of any merit. Stop. The appeals thus fail and are accordingly dismissed. Stop. In case if any of the appellants is on bail, his bail bond stands cancelled and he is directed to be taken into custody forthwith to undergo remaining period of sentence awarded to him by the Sessions Court.